Hi again. I'm Leanne Graham from Victim Assistance Program. This is the third and final video in the Civil Protection Order series. This video will help you prepare for your full hearing, also known as an evidentiary hearing. This can be a scary step for some people. There is a possibility that you will become face-to-face with the respondent or the person you are seeking protection order from. Advocates can prepare you for this process, attend the hearing with you, and or help you determine if it may be beneficial for you to meet with an attorney prior to the hearing. Our Director of Services, Becky Cool, will end this video with a discussion about how to plan for your safety during this time and additional resources available to you.
Hello, my name is Judge Katarina Cook. I'm the Administrative Judge at the Summit County Domestic Relations Court. I'm here to explain the second hearing in the court process of obtaining a civil protection order, also known as the evidentiary hearing or full hearing. You should have already watched Part 1 and 2 entitled How to File a Civil Protection Order and Service. After your initial ex parte court hearing, the magistrate scheduled the evidentiary hearing within 7 to 10 business days. That date is on the last page of your Temporary Civil Protection Order, or CPO, granted by the magistrate. When you arrive at court for the evidentiary hearing, please check in with the bailiff at the security desk on the 3rd floor about 10 minutes before your hearing. Once checked in, have a seat and wait until your case is called. Once service has been completed upon the respondent, the evidentiary hearing will go forward. The purpose is to keep in place the protection order that has been issued, or to provide you with an opportunity to seek having a protection order put in effect. At the evidentiary hearing, you as a petitioner have the burden of proof to establish by a standard referred to as preponderance of evidence. This basically means that the evidence and testimony you provide at the hearing would indicate to the magistrate that it's more likely than not that what you have stated to have occurred or your statements about your safety are as you say or believe them to be. In order for you to have a protection order issued, you must meet this burden of proof. You can meet your burden of proof through your testimony, witness testimony who have observed the acts of violence or threats, written documents including texts, emails, letters, audio or video recordings, or police and or medical reports. The respondent has the right to be present at the full hearing and respond to the information you provide to the court. This means the respondent will be present in the same room as you, cross-examine your testimony and any witness testimony, and object to any documents you offer as exhibits at the hearing. When you finish presenting your case, they will have the opportunity to present their case to explain why the court should not keep a CPO in place for you and or your household members, or why the court should not issue a protection order. If the respondent is properly served and chooses not to appear at the full hearing, you still need to appear and present your case similar to what you did at the ex parte hearing. However, it will be helpful to your situation if at the full hearing you are more detailed in your presentation and provide documents and or witnesses if you have them to support your request. At the completion of the case, the magistrate will tell you they are taking the matter under advisement and will issue a decision within 30 days. You will be notified of the court's decision by mail once it is issued. While you are waiting for the court's decision, any orders already in place remain in place until the court issues its decision. Once that final decision is issued, then that is the order that is to be followed. If you disagree with the court's decision, you will need to immediately follow up and file in writing with the clerk of courts your objection and specifically state the reasons why you object. Please put the case caption or case information, which includes the case number, on your filing. The respondent also has the right to object to the court's decision. Additionally, if a correction to the order is needed, again, a written filing needs to be timely made through the clerk of court's office, and this writing needs to clearly explain the error or admission in the order issued. If you fail to appear at the time scheduled for the full hearing and you have not requested a continuance from the court, your case will be dismissed. If an ex parte CPO was issued, it will be terminated. If this happens and you still have a good reason why you need a protection order, you will need to file a new petition and go through the entire legal process again. We are aware you are not attorneys, but you need to inform yourself as to the time restrictions provided for by law to object or to request corrections to orders, as well as what your responsibilities are for participating effectively and properly during the legal process. If the court, following the evidentiary hearing, issues a CPO, that order can remain in effect for a period of up to 5 years and can be extended further. If you want the order extended past the expiration, you will need to seek an extension in writing and request a hearing be held prior to when the CPO expires. The CPO clearly states a date when the CPO will terminate, so be aware of that date. Quite often, the provisions regarding safety measures and restrictions placed on the respondent in a full CPO hearing are the same as those that were in the ex parte order. Usually, changes are issued regarding children you have together, housing situations, and issues regarding personal property. It is important to note that the primary purpose of a CPO is for protection purposes, not allocation of property rights and financial rights. So, you can understand that the court will not be focused on property issues, except as they may relate to use and possession of a vehicle and access for the respondent to obtain their clothing and personal items. The court, as a general policy, does not issue child support orders through a CPO action, and those requests are better addressed by a separate cause of action with the court or through the Child Support Enforcement Agency. Sometimes at the evidentiary hearing, you and the respondent can come to an agreement regarding having a protection order remain in effect. If this is the situation, then the court will issue what is called a consent CPO. If you and the respondent agree that a consent CPO will be issued, then the evidence does not need to be presented at the hearing. However, through discussion with the magistrate, you and the respondent will both need to agree to each and every provision of the consent CPO. Additionally, the order is prepared that day while both you and the respondent are at the hearing, and this will be the order that you will be following. This order quite often reflects many of the same provisions that are in effect under the ex parte order. But again, you and the respondent need to work out the details of the provisions and agree to all of the provisions. Just like a regular CPO, this consent CPO can be in effect for up to 5 years and can be extended in the same manner as a regular CPO. It is important to note that a consent CPO entry is not a finding that the respondent has caused domestic violence, but rather it acts as a restraining order which restrains the respondent from certain conduct during the duration of the consent CPO. However, if the respondent violates the terms of the consent CPO, it can be enforced in the same manner as if a regular CPO had been issued. There is a lot more information that could be provided to you, but this information, though it may overwhelm you now, is meant to help you understand your rights, the legal process, and legal relief available to you. We suggest that when you prepare for the hearings, reach out to advocates when needed. They can help with safety concerns and for guidance. Advocates are not attorneys, and therefore, while they can't legally represent you at the hearings, they can serve as a good resource on how to maintain your safety, assist with preparing for the hearing, and provide you with support during the pendency of the case and thereafter. Dating and domestic violence protection orders do work. They are an important tool that can help protect you and your family. Court personnel and law enforcement take these protection orders very seriously. These people will do their best to protect you. But remember, the protection orders they issue and/or enforce are only a piece of paper. So it is important that you use your best effort to keep you and your household members safe.
I am Becky Kuhl, Director of Services for Victim Assistance Program. Now, you have just watched 3 videos with a lot of information on filing for a civil protection order, understanding service, and preparing for your full evidentiary hearing. It is very normal to feel overwhelmed at the thought of undertaking this process. Remember that above all, the most important thing to consider is the safety of you and/or your family. I urge you to call or text the Victim Assistance Program hotline if you are not already working with an advocate from a different organization. Victim Assistance Program advocates are ready 24/7 to provide free, confidential, emotional support, assist in creating a plan for your safety, answering general questions about the court process, discussing eligibility for legal assistance, and connecting you with other local agencies to help meet your unique needs. In Summit County, we are so very lucky to have resources such as the Hope and Healing Survivor Resource Center or the Battered Women's Shelter and Rape Crisis Center. They provide emergency shelter, assistance with housing, and many other services. We have organizations such as ourselves, Community Legal Aid Services, and Asia Inc. that can assist with connecting you to free or discounted legal services. Akron Bar Association can assist with connecting you to an attorney as well. Additionally, we have Asia Inc. that can help the immigrant and refugee community with interpreting services, basic needs, medical care, victim advocacy, and other culturally specific services. And Greenleaf Family Center can assist with providing advocacy, support, and interpretation services for the deaf and hard of hearing community and counseling services to the larger community. I know that it is not easy to break the cycle of abuse, but you have already decided that you're ready. Remember that your safety is of the utmost importance throughout this entire process, and that you are absolutely worthy of peace, safety, stability, and respect. We are here if you need us. Please remember to clear your search history and your computer's cookies to add an additional layer of safety as you begin this courageous step in petitioning the court for a civil protection order.